Imagine you are sitting in your living room on a quiet Tuesday evening. You have not committed any crime. You are not bothering anyone. There is no warrant with your name on it. No judge has signed anything. But there is a knock at your door, and within the next 20 minutes the police have walked into your home, picked up your legally owned firearms, put them in a bag, and driven away. You have not been arrested. You have not been charged. You are standing in your own house, perfectly free, with no guns. This is not a story from a dystopian novel. This was happening all across America, legally, and most gun owners had absolutely no idea it was even possible until now, because the Supreme Court of the United States just handed down 2 back-to-back rulings that have completely changed the legal battlefield for every single gun owner in this country. And I am not talking about a 5-4 partisan decision that gets thrown out in 4 years. I am talking about 9-0. Every justice, from Clarence Thomas to Sonia Sotomayor, in agreement. When the entire court agrees, the rules change overnight. And they change for everyone, in all 50 states, effective immediately. What I'm going to break down for you today is not just legal theory. This is the practical, real-world impact on what can and cannot happen the next time a neighbor calls a non-emergency line because they are worried about you. This affects your Second Amendment right to keep your guns. It affects your Fourth Amendment right to be free from unreasonable searches. And it affects what you should do right now, today, to protect yourself. Most gun owners have no idea any of this just happened. You are about to be one of the few who does. So let us start from the very beginning, because to understand why these rulings are so significant, you first have to understand the trap that was being used against gun owners for years before any of this landed in front of the Supreme Court. For decades, law enforcement had a quiet legal loophole called the community caretaking exception. The original idea was reasonable enough. If a car breaks down on the highway and gets abandoned, police can search it to make sure there is not a loaded weapon sitting in an unlocked vehicle on the side of a public road. That was the original scope. Cars, highways, public safety. Makes sense. But then something crept in that should alarm every person who owns a home. Lower courts started stretching that car rule and applying it to your front door. They reasoned that if a neighbor calls the police saying they are worried about you, if an ex calls in a report that you seemed upset, if anyone with a phone dials 911 and uses the right words, the police should be able to enter your home without a warrant to check on you, not to arrest you, not because a crime was committed, just to help. And here's the part that should make your blood run cold. When they enter to help, the first thing many departments were trained to do was locate and secure any firearms on the premises. They did not call it a seizure. They called it safekeeping. But the result was the same. You are standing in your own home, you have broken no law, and your guns are leaving in a police vehicle. No warrant, no judge, no crime. Just a phone call from someone who said the right words. This was not some fringe practice happening in 1 or 2 cities. It was documented, trained policy in departments across states like Illinois, New Jersey, Maryland, Massachusetts, and California. States that issue carry permits, but then use the existence of those guns as a reason to expand what police could do when they showed up at your door. Let me tell you about a man named Edward Caniglia, because his story is the one that finally cracked this entire system open. Edward had an argument with his wife. It was a bad night, a heated argument, and in a moment of dramatic frustration, he put an unloaded handgun on the table and said something like, "Why don't you just shoot me and get it over with?" He was not suicidal. He had no criminal record. He was having a terrible evening, and he said something he probably regretted. His wife called the police for a welfare check. When officers arrived, they convinced Edward to go to the hospital voluntarily for a mental health evaluation. He agreed to go, but he made one condition very clear before he left. He told the officers, "Do not touch my guns." He had not done anything illegal. His firearms were legally owned. He just wanted them left alone while he was gone. The moment Edward's car pulled out of the driveway, the police turned to his wife and told her he had consented to the seizure of his weapons. That was a lie. Edward had said the exact opposite, but his wife, trusting the officers, let them in. They walked through the house and took every firearm. When Edward got out of the hospital, cleared by the doctors who evaluated him, he went home to find his guns were gone. He called the department. He asked for them back. They refused. This man had to hire a lawyer and file a lawsuit to recover his own legal property from a government that had no right to take it in the first place. His case worked its way up through the federal courts and eventually landed at the Supreme Court, and that is where the government made an argument that tells you everything you need to know about how far this had gone. Government lawyers stood before the 9 justices of the Supreme Court and argued that the sanctity of the home should take a back seat to the caretaking role of police. They wanted a standing permission slip to enter any home any time an officer decided it was reasonable. The Supreme Court did not just disagree with that argument, they destroyed it. In a unanimous 9-0 ruling, Justice Clarence Thomas wrote the opinion, and he was crystal clear. What is reasonable for vehicles is different from what is reasonable for homes. The community caretaking exception applies to cars on public roads. It stops at your front door. That ruling, known as Caniglia versus Strom, drew a red line around the American home. It told law enforcement across every state in this country that you cannot use a welfare concern as a backdoor warrant. You cannot dress up a seizure as safekeeping and walk away with someone's legally owned firearms without a judge ever signing a single piece of paper. Now, if that were the end of the story, it would already be one of the most important Second Amendment victories in a decade, but it is not the end, because while the Caniglia ruling slammed one door completely shut, it left another door cracked open. And every gun owner in America needs to understand exactly where that crack is, because that is exactly where the next threat is coming from. The door that remains open is called the emergency aid exception. This is fundamentally different from community caretaking, and the distinction can mean the difference between keeping your guns and watching them leave in a police vehicle. Here's the line. If the police show up and say they are there because they are worried about your mental health or your general well-being, that is caretaking. After Caniglia, they generally need a warrant for that. But if they show up and say they heard a gunshot, or someone reported you might already be injured, or there are signs of an active emergency on the property, that is emergency aid. And under that exception, the Fourth Amendment protections that normally require a warrant are significantly weakened. The Supreme Court addressed this distinction directly and unanimously in a follow-up ruling, and the facts of that case are something every gun owner needs to hear, because they could happen to almost anyone. A man was at home, his ex-girlfriend called 911 and told the dispatcher that he was suicidal and might have already harmed himself. Officers arrived at his residence. They knocked. They announced themselves through a window. No answer. Then they looked through a window and saw three things: an empty handgun holster sitting on a surface, some beer cans, and something that looked like it might be a note. Based on those three observations, the officers decided they did not need a warrant. They entered the home to render aid. When they got inside, the man was in a closet. When he stepped out, the officers shot him. He survived. He was later charged with assaulting a police officer. His attorneys moved to throw out all the evidence against him, arguing the police had no right to be in that house without a warrant. The Supreme Court took the case and issued another 9-0 ruling, and this one cuts in a very different direction. Justice Elena Kagan wrote the unanimous opinion, and here is what she said. While community caretaking is for cars, the emergency aid exception is very much alive for homes. If the police have an objectively reasonable basis to believe someone inside is seriously injured or in imminent danger, they can enter without a warrant. The court found that the empty holster, the note, and the 911 call together created that objectively reasonable basis. They did not need proof the man was actually hurt. They only needed a reasonable belief that he might be. Now sit with that for a moment, because the implications for gun owners are enormous. You are a person who legally owns firearms. You own holsters. You own ammunition. You have an ex, or a difficult neighbor, or a family member you had a falling out with. That person calls 911 and says the right words, that you have a gun, and you are acting like you might hurt yourself or someone else. Officers arrive at your home. They look through a window. They see your empty holster on the counter where you left it. They see a glass of whiskey on the table. They see a piece of paper that might be a letter, or a note, or a grocery list. Under this ruling, that combination of observations could be enough for a judge to later rule that the entry was legally justified. And once those officers are legally inside your home, something called the plain view doctrine kicks in. Whatever they can see from where they are legally standing, they can act on. If your state has restrictions on magazine capacity or certain rifle features, and your firearm is sitting in plain sight, they can seize it right then and there. They did not come for the gun, but they are taking the gun. And here is the part of this ruling that is genuinely chilling. The standard the court set, objectively reasonable belief, is significantly lower than probable cause. Probable cause is the traditional Fourth Amendment bar that has protected Americans for over 200 years. It requires real evidence. The objectively reasonable standard does not require the officers to be right. It only requires them to show that a reasonable officer in their position would have thought there was an emergency. Even if you were perfectly fine, even if the call was completely fabricated, the entry into your home can still be ruled constitutional as long as the officers can point to something they observed that contributed to their concern. This is not a hypothetical abuse. This is the exact mechanism being used in states with weak red flag laws, and now it has a 9-0 Supreme Court stamp of approval. It is essentially a red flag seizure without the red flag law. A disgruntled person with a phone and the right vocabulary can set the entire process in motion. So what does all of this actually mean for you, and what can you do about it right now? The first thing you need to understand is how you handle the moment the police knock on your door for a welfare check. Most people make the same instinctive mistake. They open the door, they step out onto the porch, they try to be cooperative and friendly, and they leave the door slightly ajar behind them. Stop doing that. The moment that door is open, even a few inches, you have given officers a window into your home. If they can see an empty holster, a gun case, a box of ammunition, anything they can characterize as consistent with the concern that triggered the call, you have just handed them the foundation for an objectively reasonable emergency entry. Keep the door closed. Speak through it, or through a doorbell camera, or through a window. Be calm. Be polite, but be closed. The second thing involves how you respond when they tell you they are coming in. The old advice was simple. Say, "I do not consent to a search." Under the Caniglia ruling alone, that phrase carried a lot of weight for caretaking situations. But after the emergency aid ruling, if the officers frame their entry as a response to a potential emergency rather than a general welfare concern, your non-consent actually becomes a problem. They will tell a judge that your refusal to open the door and let them verify your safety only increased their concern that you were incapacitated or in danger. The better approach, and this is critical, is something called compliance under protest. If officers insist they are entering to render emergency aid, and it is clear you cannot physically stop them without making the situation dramatically worse, do not resist. Instead, make your position clear on the record. Say, "I am complying with your entry, but I am not consenting to a search of my property. I am telling you right now that I am safe. I am not injured. I do not need medical aid, and there is no emergency in this home." Say it clearly, say it calmly, and say it in front of any camera you have running. Why does that matter? Because the entire legal justification for the warrantless entry collapses the moment the officers can see with their own eyes that there is no emergency. The Supreme Court was explicit that the emergency aid exception is limited in scope. Officers can enter to locate and assist a person in distress. They cannot use that entry as a general license to open your gun safe, search your closets, or rummage through your drawers looking for violations. The moment you are standing in front of them, clearly uninjured and clearly not in crisis, their legal authority, under the emergency exception, has been satisfied. Anything they do after that point, any search of your belongings, any opening of locked containers, moves them back into warrant-required territory. This brings us to the most practical thing you can do right now to protect your firearms from a plain view seizure. Every gun that is not on your body should be in a locked container, not a soft case with a zipper, a locked, hard-sided, opaque safe. The Supreme Court was clear that the scope of an emergency entry is limited to the emergency itself. Officers cannot open a locked gun safe to render medical aid to a person because a person in distress is not inside a gun safe. A locked container puts your firearms behind a Fourth Amendment wall that even a valid emergency entry cannot easily breach. A quick-access biometric safe on your nightstand keeps your home defense firearm accessible to you in seconds while placing it behind that legal protection at all times. Beyond the physical setup of your home, there is a strategic step many gun owners have never considered. If you are going through a contentious divorce, a difficult neighbor dispute, a heated situation online, or any circumstance where someone with a grudge might make a false call, contact your local department's non-emergency line before anything happens. Tell them you are a law-abiding gun owner, that you have a specific concern about a specific person making a false report, and that you want that conversation documented. It does not prevent them from responding to a 911 call, but it creates a paper trail that a defense attorney can use later to challenge whether the responding officer's belief in an emergency was genuinely reasonable or whether they should have known the call was likely fabricated. And if the worst happens, if the police enter and take your firearms, there is one more thing you absolutely must know. Do not try to talk your way into getting them back at the scene. Do not try to explain yourself to the officers or to their supervisor in the parking lot. Every word you say in that moment is being recorded, and anything you say can be used to construct a justification for keeping your property. Instead, immediately contact an attorney and file a formal motion for return of property. Force the government to demonstrate in front of a judge that they have a legitimate legal basis to retain a citizen's firearms when that citizen has not been charged with any crime. The Caniglia ruling is particularly powerful here. "We were concerned about him" is no longer a sufficient legal justification to keep someone's guns after the emergency has been addressed and the person is clearly fine. The court has said so unanimously. Use that. Now, there is a broader pattern here that goes beyond welfare checks and front doors, and it directly connects to something the Supreme Court has also been addressing when it comes to your rights during encounters with police outside your home. For years, in state after state, law enforcement operated under an unwritten doctrine that went something like this. If we know you have a gun in the car, we have a reason to search the car. It was not official policy written in any statute, but it was trained behavior in departments across the country. Illinois, New Jersey, Maryland, California. These states issue legal carry permits, and then their officers were using the existence of a legal firearm as justification for expanded searches during traffic stops. The permit itself, the thing that proved you were a law-abiding citizen who had passed a background check, was being used against you. The Supreme Court's recent direction is clear. The exercise of a constitutional right cannot be treated as evidence of criminal activity. If you are legally carrying a firearm, that fact alone cannot be the basis for a search of your vehicle or your person. A legal gun does not equal reasonable suspicion. A legal gun does not equal probable cause. The Constitution protects the right to keep and bear arms. A government that uses the exercise of that right as a trigger for diminished Fourth Amendment protection is undermining both amendments simultaneously. The same logic extends to how states have been handling permit databases. Some states had created a system where having a carry permit, being a registered, background-checked, law-abiding gun owner, actually made you more likely to face expanded scrutiny during a police encounter. Officers could run your name, see the permit, and trigger a different protocol. The Supreme Court's consistent message is that participation in a state-run licensing system cannot be turned into a mechanism for stripping participants of their constitutional rights. These are not small technical legal points. These are direct attacks on the fundamental idea that lawful gun ownership is a right, not a privilege that comes with reduced freedom. The courts are finally drawing those lines explicitly and drawing them unanimously. There is also a critical development when it comes to storage laws that several states have been using to effectively eliminate your ability to use a firearm for home defense. California, Massachusetts, Connecticut, New York, and Hawaii all have laws requiring firearms to be stored in locked containers or rendered inoperable with a trigger lock when they are not being actively carried on your person. On the surface, these sound like safety measures. In practice, they mean that if someone breaks into your home at 3 a.m, by the time you have unlocked your safe or removed your trigger lock, the situation may already be over. The Supreme Court's message on this is grounded in a principle established years ago and reinforced repeatedly. The core of the Second Amendment is the right to have a functional firearm in your home for self-defense. A law that requires your firearm to be in an inoperable state directly contradicts that core right. These storage mandates are now on extremely shaky constitutional ground, and legal challenges are already being prepared in several of those states. If you live in one of them, do not assume those laws have already been struck down. They have not been. But watch that space closely because the legal ground has shifted dramatically, and the next chapter of that fight is already being written. Here is the bigger picture that ties all of this together. We are living through a moment where the Second and Fourth Amendments are being defined simultaneously by a court that is unanimous on some of the most important questions. That 9-0 number matters more than most people realize. A 5-4 decision can be relitigated. It can be chipped away at over time by new appointments and shifting majorities. But when all 9 justices agree, the legal foundation is as solid as it gets. It is not a partisan position. It cannot be dismissed as conservative overreach or liberal activism. It is the unified voice of the highest court in the country, and it changes what law enforcement can and cannot legally do to you. But here is what makes this moment complicated, and why you cannot afford to be passive about it. These rulings do not enforce themselves. A police officer responding to a 911 call at 11 o'clock at night is not going to stop and read a Supreme Court opinion before deciding whether to push your door open. The protections these rulings create exist on paper, and they become real only when people know about them. Invoke them correctly in the moment, document their encounters, and pursue legal remedies when their rights are violated. The qualified immunity doctrine means that even when officers get it wrong, even when they enter a home without legal justification or seize firearms they had no right to take, suing them individually is extremely difficult. The court has signaled that agencies which continue to train officers under policies that have been ruled unconstitutional, after having clear notice that those policies are unconstitutional, face a different standard. Continued violations after a period of reasonable implementation time can move from officer error into deliberate indifference, and deliberate indifference can defeat qualified immunity at the department level. That matters because it creates a financial incentive for police departments to actually update their training and their policies in response to these rulings, rather than quietly ignoring them. The practical implication for you is simple. Document everything. If you have a doorbell camera, make sure it is recording. If you are in a state where you can legally record your interactions with law enforcement, do it. Know the date of these rulings. Know the case names. If you are ever in a situation where an officer attempts to search your vehicle because you have a legal firearm, or attempts to enter your home under a caretaking framing rather than a genuine emergency, that documentation becomes the evidence your attorney needs to make the violation real and consequential. The media is largely not covering any of this, and the reason is not complicated once you think about it. A unanimous Supreme Court ruling that expands gun rights while simultaneously strengthening civil liberties protections does not fit cleanly into any political story that drives clicks and engagement. Gun rights expansion is supposed to be a conservative story. Civil liberties expansion is supposed to be a liberal story, when the same ruling does both. When Clarence Thomas and Sonia Sotomayor are signing the same opinion, there is no culture war angle to package it with, and so most outlets simply move on to something that generates more outrage. But that silence has consequences for real people with real firearms in their real homes. The neighbor who does not know these rulings exists. The gun owner who opens their door wide during a welfare check because they want to be cooperative and helpful. The person who says nothing when officers enter because they do not know they have the right to verbally establish the record. These are the people who lose their firearms to a system that depends on them staying uninformed. You now know what most gun owners do not. You know that the community caretaking exception is dead at your front door. You know that the emergency aid exception is still alive, and you know exactly what conditions have to exist for it to apply. You know the difference between a caretaking entry and an emergency entry, and you know exactly what to say to challenge the legal foundation of that entry in real time. You know why locked containers are your most important practical protection. You know why documentation matters. You know why storage laws in 5 states are now on contested constitutional ground, and you know what to do if your firearms are taken to get them back. The law is moving fast. These rulings are the beginning of a legal shift, not the end. The battles they trigger, over red flag procedures, over permit databases, over storage mandates, over what evidence gathered in unconstitutional searches can be used to convict, will play out in courtrooms across the country over the next several years. Every one of those fights matters. Every one of them will define what your rights actually look like on the ground versus what they look like on paper. A disarmed citizen is a subject. An informed citizen is something the government has a much harder time controlling. Know your rights. Protect your property. And share this with every gun owner you know, because the next welfare check that goes wrong might be theirs, and what they do not know could cost them everything.